I want to talk about statutes of limitations and statutes of repose in the context of construction projects. All states have what is called a statute of limitations, and that basically cuts off the right of somebody to sue the party that's responsible for their injury after a certain period of time. Most states have what's called a statute of repose, which is a very similar concept, but that provides an outside time limit within which to sue. Now, the reason you have this statute of repose on top of a statute of limitations is that, let's say you're walking past a building and a piece of the roof blows off and injures you. You then have a certain period of time as determined by that state's law within which to sue whoever might be responsible. So, for example, in Illinois currently, the statute of limitations is 4 years for construction, and that includes actions against the architect, the builder, the owner, and so forth. But let's say it's something more subtle. Let's say it's a roof leak. You're the owner, and 2 years after the building is completed, you notice a spot on the ceiling, you do some investigation, and it turns out that there's either a construction defect or a design defect. So the law, as it's currently interpreted, is you have the statute of limitations period from the time you knew or should have known of a defect. So in my example, you didn't know anything until 2 years after construction was completed. So your statute of limitations period starts to run at that 2-year mark, and if you were in Illinois, you would have 4 years from the time you discovered it until the time you have to sue or your claim is cut off. Now, Illinois does have a statute of repose, and that happens to be 10 years currently. So if you discover this roof issue 9 years and 11 months after completion of the project, you still have an additional 4 years. However, because of the 10-year statute of repose, if you don't discover that problem until 10 years and 1 day after construction is completed, then the statute of repose cuts off your rights completely. Again, this is different in every state, so you really have to look carefully at the laws of the state where that project is located. And that rule that you have from the time you discover something, that's called the discovery rule. Now, the agreement between the parties to a construction contract, whether it's the owner-architect agreement or the owner-contractor agreement, that agreement can have a private statute of limitations. So for instance, I have a project in Illinois, I'm the architect, I would like to have that statute of limitations period as short as possible because I want to cut off claims against me. So if the owner is agreeable, in my contract with the owner, I can say the statute of limitations is only 1 year. Now, of course, that only affects my right as to the owner, the time in which the owner can sue me or I can sue the owner. Contractor can do the same thing. That does not affect the rights of third parties. So a visitor to the building, my agreement with the owner doesn't affect that person's rights. Those are whatever the local state statutes are in terms of statute of limitations and statute of repose. So the statute of limitations, those rights are important as a design professional or as somebody else involved in construction. You should be aware of what those are, and if you find something wrong, you need to promptly investigate and find out who might be at fault, because if the statute of limitations runs out on you, then you won't be able to either bring a lawsuit or an arbitration action against the party that caused your injury.